Hello and good afternoon, everyone. We'd like to welcome you to our first in a series of webinars discussing housing issues and property rights in 2022. These webinars are brought to you by the Small Property Owners Association, also known as SPOA. My name is Amir Shahsavari. I'm the Vice President of SPOA. I'm joined by Mr. Chris Lehman, my fellow SPOA board member who came to us recently. Today, Chris and I will co-moderate this presentation, which will focus on a proposal to enact a tenant right of first refusal in the sale of rental property statewide throughout Massachusetts. Currently, these proposals take the form of Senate Bill 890 and House Bill 1426. There's also House Bill 4208, which applies to the city of Somerville exclusively. These bills are very dangerous. They present several problems. They prevent property owners from selling their properties at market value in the open market. They artificially block free market buyers from purchasing and investing in rental property. They decrease the availability of rental housing itself. And they produce circumstances where tenants would be used as pawns in a game where a small subset of lawyers and speculators would emerge as the winners by using the tenants to delay the sale of properties in order to extort more money from the property owners. So a version of this proposal called the Tenant Opportunity to Purchase Act, also known as Topa, passed in Washington, D.C., where it failed. Only 5% of renters actually ended up buying the properties that they rented under this policy. And tenants were also found to be assigning their so-called Topa rights to speculators for large sums of money, thereby delaying the process even further. Topa and tenant right of first refusal are two terms that'll be used interchangeably during this presentation, but they mean the same thing. And you'll notice that there's a chat box at the bottom of your screen as the presentation continues. If you have any questions, you can feel free to type those questions into the chat box, and if time permits, we'll be happy to address those questions. So as property owners and housing providers, we are confronted by a lot of alarming proposals that are moving forward on Beacon Hill, including Topa, including rent control, and other policies that aim to drive us out of business by making it impossible to collect our hard-earned rental income, and by making it nearly impossible to remove tenants who are non-compliant, not only to our detriment, but to the detriment of the many good tenants who are compliant and who depend on us to provide them with safe, maintained places that they can call home. In the end, these policies harm owners, they harm tenants, and they harm the housing stock itself. So we have to remember the value that small housing providers bring. We are primarily small businesses that are female, minority, and family owned. We support our communities through the taxes that we pay. We also give business to other businesses, both large and small. All the people who help us maintain our buildings, the plumbers, the electricians, the carpenters, the material suppliers, attorneys, the banking industry, the brokers, the list goes on. So therefore, we have to remember that when we see people holding up signs that say housing is a human right, cancel rent, property is about people, not profit, we understand that it is about people, but we have to remind those folks that we're people too. We're the people who care. We're the people who provide the housing, and we have rights. And even though prices are going up, we have to remind folks that the costs associated with maintaining and running our buildings are also going up, which pose another challenge. So in order to fix the pricing issue, we have to focus on broader solutions that help everyone instead of scapegoating and victimizing property owners. So in order to donate, you can go to spoa.com/join and add the words Topa webinar in the comments field when you donate. We would like to note that the donations that we receive will be shared equally between the Small Property Owners Association and the Somerville Property Owners Coalition, also known as SPOC. One of their representatives will be speaking today. They have fought very bravely against a very malicious ordinance that restricts condo conversion in Somerville, so we do look forward to hearing from them. And to conclude my remarks, I just have to say that, at this point, I have to borrow a line from Henry Nouwen, who said that when people are confronted by darkness, they have to rise up to be the light. They have to be the light for themselves and for others to get through difficult times. And hopefully we can be the light. Hopefully we can convince the folks on the other side that we do good work and that we should be voices at the table. And hopefully we can convince the people who do make the laws that they should listen to us for the sake of making housing policies that are rational and fair for everyone. And having said that, it's my pleasure to turn it over to Chris Lehman, who will introduce the panel.
Thank you, Amir. So I just wanted to talk a bit about the context briefly before going on into the introductions. As many of you know, the housing crisis in Massachusetts has grown particularly severe over the past few years, with continually increasing demand and artificially constrained supply of housing, leading to unprecedentedly high prices. This has led to immense pressure for policy solutions, translating into dozens of individual pieces of proposed legislation. While many of these proposals are well-intended, some of them are likely to have significant negative side effects on the housing market and the broader economy. Our panelists are here today to help us understand both the details of one such policy, Topa, as well as to provide additional context on the political climate around Topa and other proposed housing policies. So without further ado, I'll discuss our panelists. First, we'll be talking with Jeff Turk, who's an expert in landlord-tenant law, representing many of the country's largest commercial and residential landlords, as well as several housing authorities. He's an active member of several real estate trade associations, previously serving on their boards. He's also local counsel to the Greater Boston Real Estate Board and the National Apartment Association. Second, we'll be talking with the leadership of the Somerville Property Owners Coalition, or SPOC. Steve Bremis has been active in Somerville real estate for over 40 years, personally selling over 1,400 homes, in addition to leading the Steve Bremis Realty Group and serving as the chair of SPOC. Steve Broadley is a member of the complex litigation group at Arendt Fox Schiff, where he represents businesses and individuals in contractual disputes, tax abatement issues, landlord-tenant disputes, and other business litigation matters. Finally, we'll be talking with our advisors from Preti Strategies. Richard Tisei is the former Massachusetts Senate Minority Leader, former Republican nominee for Lieutenant Governor, and state chairman of the Baker for Governor campaign. Jim Eisenberg was chief of staff and chief policy advisor to Speaker of the Massachusetts House of Representatives, Bob DeLeo, and his 19 years of experience on Beacon Hill. To start off with, we'll have our conversation with Jeff Turk. Jeff, how are you doing today?
I'm wonderful, thank you. Thanks for inviting me today. Good.
Glad to hear it. And of course, we're looking forward to hearing your thoughts. So let's get into, before I go into any questions, do you have any broad thoughts about Topa in particular?
Yeah, so I guess let me start off by making sure that everybody has a good understanding of what Topa is, right? Because as with many things that sound good, right, you start off by looking at, tenant opportunity is in the name of the law. What's wrong with opportunity, right? What's wrong with purchasing, right? Sounds great. When you sell the property, right, everybody's money's green, they say, right? Nobody's money's more green than anybody else's. So sounds like a great idea, but then you have to look at the devil's in the details, right? So I thought maybe I'd spend a couple of minutes first just making sure everybody's clear on what this law would provide and what it would require from owners. So let me start by just saying, first of all, this law would only apply if a town enacted it. So this is a law that would say town or cities, you can enact this law and then it will go into effect. And if they don't enact it, it would not apply in your town. So it would really be up to your city council, whatever your governing body is in your town, to enact it. So that's the first part. How would it work? So step one would be whenever rental property was to be sold, there would basically be what's called a right of first offer. So when you intend to sell your property, you would first have to notify the municipality and all of the tenants that you're intending to sell the property, and you'd have to provide a form, a summary of rights that the town would create. What that form would be, we have no idea, because it just says the town can adopt it. But That's the first thing you'd have to do. I want to sell my rental property. I have to give every tenant of the building and the town notice I'm going to do that. And then the tenant association has 30 days to decide if they want to make you an offer, right? So you have to wait 30 days. There's this 30-day waiting period to see whether they make an offer. And if they make an offer and you accept it, they then have 30 days to enter into a purchase and sale agreement. So right off the bat, you see we got this 30-day waiting period, maybe a 60-day waiting period before you can really go out there and try to sell your property, okay? Step 2 is what's called a right of first refusal, right? You go find a buyer, you negotiate your purchase and sale agreement, you get a price, you get all the terms, and then once you have a fully signed purchase and sale agreement, you have to provide the tenants association, I'm going to talk about who that would be, within 7 days, a copy of that purchase and sale agreement, a rent roll with all of the tenant names and all of their rental information. You have to give a documentation showing all of your expenses on the property for the past 2 years. You have to give the tenants the right to perform an inspection of the entire building and all of the units. And you have to give all of the tenants copies of all your expenses for the building, all of your expenses for the building. So you're giving this huge package with all this information that I think we can talk about more, the ramifications of that, within 7 days of signing that purchase and sale agreement. And then this tenants association has 30 days. 30 days to either match that offer and sign a P&S. And it's not your purchase and sale agreement. It's a purchase and sale agreement that the town creates to match that price. So yeah, they have to match the price, but what's really important in the details is they don't have to match the rest of the terms. Rather, for example, the deposit that you may have worked out with your buyer, you can't require from the tenants association. You can only require a deposit of the lesser of 5% or $250,000. That deposit has to be refundable for 90 days. And your purchase and sale agreement with the tenants or with the municipality has to have reasonable contingencies, including financing, title, and any other appraisal and any other reasonable contingencies. So you've got your no refundable deposit, no contingency cash purchase and sale agreement. The tenants don't have to match that, right? And they have 160 days then to complete those contingencies, right? So your P&S says no contingencies, no inspections, no nothing, cash deal. The tenants only have to match the price, and then they have 160 days, right? So my Catholic school math says that's over 5 months to meet these contingencies, and they can get out of the deal if they aren't satisfied with any of those contingencies, okay? And only if the tenant association does not exercise that option, or if they don't close within that period, can you then go ahead and sell to your buyer in that purchase and sale agreement, right? And let's remember, there's no requirement that the tenants maintain affordability. There's no requirement that the tenants can't evict everybody from the building. And of course, 6 months later, is your buyer still going to be there waiting to purchase this property? You know, that's the big question, right? I think the other thing that you have to understand, and is a major issue with these bills, is what is a tenants association, right? As noted, it's not the tenants that have the right to buy the property, it's this tenants association. And that association is a group that says that it has the consent of at least 51% of the tenants. And it's formed by simply filing a form with the town saying, yep, I'm the tenants association, or by creating a nonprofit corporation. It doesn't have to even be a legal entity. You can just go down to the town and say, hey, I've created a tenants association. I got 51% of the people in the building saying I'm their tenants association. And the statute says it's assumed that that tenant association has the consent for 1 year from the date it's formed, right? So no requirement to certify how they got the 51%, no requirement that be a nonprofit, and as we'll talk about, I think more, no requirement of how this association is governed. Is it a democratic association? Do they vote on all these terms? What if they form a president and the president says, I want to offer this amount, and the other residents say, we don't want that? How does this get governed? Nothing in there about it. And also, I think as Chris or Amir was mentioning, it can be assigned. The tenants can assign their rights to a nonprofit if the nonprofit agrees to keep it affordable, or to the town or local housing authority if they want. Who does this apply to? And I think this is also something Amir mentioned. It applies to all rental housing. All rental housing other than affordable housing projects, fine. The sale to a family member for less than market value, got it. Or if a person owns a property with less than 6 units in the town and they live in the Commonwealth, right? So some might say that means, oh, if I own less than 6 units, it doesn't apply. It's not what it says, right? If you own the property in a trust, this applies to you. If you own it in an LLC, this applies to you. Or if you rent out your single family home or your 2-family and you move down to Florida, this applies to you because you no longer reside in the Commonwealth, okay? So summing it up, the law, and again, I'm just the lawyer. I'm going to leave it to Mr. Tisei and Mr. Eisenberg to get into policies. I'm always very happy that I don't have to be a politician. I don't have to deal with the policy part. I'm just the lawyer, right? But 30 days to make the first offer. So your property is off the market for 30 days. 30 days to sign a P&S, okay? 7 days to give the tenant the P&S once they once you do it with all of your files. 30 days for the P&S, 160 days of due diligence. My math, 257 days this property can be off the market. 257 days waiting to close. And again, if your buyer and your P&S says, I'm done, I can't wait any longer, right? Back to step one, right? Intent to sell, offer, and all of that. So, Chris, my comments, so that's the law. Happy to discuss it more, but you know, what I see from this, again, being in the trenches, representing landlords for 30 years, what I see is, number one, this is a serious impediment to selling your rental property, right? 257 days you can be held without being able to sell your property. At least 3 months, the 30 days for the notice of make an offer, 30 days to accept, 30 days for P&S, right? Are buyers going to sit around and wait for this property to be on the market? The effect on the housing market is going to be significant. And remember, this isn't just a 100-unit building, right? This is a single family home if you rent it and move to Florida, or if you have it in an estate planning trust, or you keep it in an LLC. I have a condo. I swore I would never buy a condo. I swore I would never buy a condo in a 3-unit condominium, and I swore I would never rent it to my kids. I currently own a condo that I rent to my kids. It's the 3-unit building. I own it in an LLC. This would apply to me, right? If I go to sell that property and my kids say, we don't want you to sell it, or they have a roommate, right? Yeah. 51% of them get together, they have these rights. As Amir said, these also can be used for nefarious purposes, right? To hold the property off the market, to make the landlord not be able to sell the property, to play these games for nefarious reasons. But I think the other thing very concerning is, who are these tenants associations, right? Who controls them? It's not required that the tenants even get to vote on this once they form the tenants association. How do they make decisions? If I vote to be one of the 51% to form the tenants association, but then I don't agree with what the tenants association is doing, do I have a democratic right here? Is there voting? How are decisions made by these tenants associations? And what if there's more than one tenant association? I'm the tenant association. It reminds me of Spartacus, right? I'm Spartacus. I'm the tenant association. No, I'm the tenant association. Litigation ensues, and the property sits there waiting to figure out who really is the tenants association. But the final thing I'll say is, this disclosure, this information that we're going to give out to the tenants, can you imagine? I'm going to open up your tenant files to all of these tenants. I'm going to give them the name of everybody in the building. I'm going to give them their social security numbers, their income, their disability information. Can you imagine? To all the tenants,
Right.
they get everything about their neighbors. Creates really significant privacy issues there. And again, potentially illegal for me to disclose all this information out there to every tenant in the building just because they say we want to exercise the right to buy the building. So I'll leave it to the policymakers to decide whether it's good or bad, but this bill creates significant issues and delays and has serious potential consequences, not just for the owners, but also for the residents whose private information is going to be given out. So.
Yeah, thank you for that. Phenomenal detail there, and really, I think cutting through some of the uncertainty that exists around this bill in the broader atmosphere. So, one thing I want to zoom in on there a bit there is the details of how the tenant association is formed. So, you need 51% of the signatures of the tenants in the building. How is that verified? How does the town know that these are in fact the signatures of those tenants?
The bill says it just goes up into you file a form with the town. It doesn't even say what the form is going to say. So you can form a nonprofit association, or you can just form just file this form with the town, and that's the question, right? I mean, I represent the cooperatives, right? I have a bunch of cases right now where cooperative members are saying that's not the board, that wasn't a valid election. And there's litigation ensuing over it. And of course, while that fight's ensuing, is the property being sold? No, right? So that's one thing. How do they verify it's a 51%? What do they have to do to get that consent? How do they do it? Doesn't say. And more importantly to me, as important is, how are decisions then made? There's nothing that says if the 51% say, yeah, let's do it, and then they elect a board and the board says, you know what? We want to be market housing and we want to evict the 49% of the people who didn't vote for us. Right. We're going to evict them all.
Right. Yeah.
Right. Doesn't say you can't do that or even how.
Yeah. So that's interesting, right? Because typically you think of a nonprofit as having to demonstrate in some way that it's serving the public good. Whereas in theory, the nonprofit here doesn't have to respect the wishes of the current tenants in any way once 51% of them have given permission. And can then go on to redevelop the property or bump up rates by a huge amount, let in new tenants, et cetera. Presumably lots of the same things that the advocates of this bill would oppose. But there's, at least ostensibly, how the bill's written, who knows what challenges it would run into. There's no guarantee that any of that would be the case.
Right. And I think it's really important to note that this is not a bill that protects affordable housing. It's not an affordable housing bill, right? It reminds me, I'm old enough to remember rent control. I know I had a lot more hair back then. Right. And rent control was a lot about, you just got lucky and you were living in that building when rent control hit. Didn't matter that you were low income. It didn't matter that you were the people that we want to provide a safety net for, which we do, right? You happen to be there. This is the same thing. You happen to be in a building. You could form this association. You could form this tenants association and renovate the building, go condo, do whatever you want to do with it. There's nothing that says it has to be maintaining affordability other than for elderly residents. If it's a nonprofit, you obviously have to comply with the purposes of the nonprofit. But if you're just a tenant association, this is a windfall that you happen to be living there at the time.
Right, makes sense. So there's kind of broad permissions created by the state legislation that's being proposed right now, but are all existing Topa bills the same? How does this compare to ones that have existed in other places, like the DC one that Amir had mentioned? And what are ways that conceivably, if this bill were to get passed, what are modifications that could be proposed to it to make it less harmful?
Yeah. So I think one thing is, it's a time period, right? And what we've seen in other states that have tried this is it gets abused, right? Again, I start off with tenant opportunity to purchase, right? Great. let's give the tenants an opportunity to purchase. I don't care, right? You probably don't care if you're selling your building. If I get money, I get money. Great. The problem is the inherent delays. And what you saw in other states was tenants would use this to just delay and delay and delay and delay. And then the deal would break down after, 6 months, and the landlord would have to start over. And then they would play the same game again. We want to exercise our rights again, right? So, if there's a matching of an offer and it's the same terms, who cares, right? Who buys it? But it's these inherent delays that you put in there, and these other problems that you have. I will say that this law did try to include a provision that says the tenants and the tenant association can't sell their rights, because that was happening down in DC. Was smart tenants were saying, oh, you don't want me to do this? Give me $100,000, right? So this says that the issue is always going to be in the details, right? Like, how do you enforce that? Are tenants really not going to be reaching out and saying to developers, you know what, give me something, and I'll give you my rights here. So that's something that they tried to do. But to me, it's the delay. It's the disclosure of this information, which is really troubling. And can you imagine? I mean, again, buyers often don't even get that, or they sign a non-disclosure agreement, right? Yeah. I'm not going to give a tenant file to a buyer without a non-disclosure. I'm not going to give social security numbers out. I'm not going to give rental histories out. And now we're giving all that information to everybody, right? And can they then publish it? So that's the other troubling thing about this.
Got it. So on that subject of transfers, so the existing Massachusetts proposal, as I understand it, doesn't allow a tenant association to directly assign its rights to a for-profit developer, but it does allow them to hold on to the rights or sell it to someone else. Is there any prohibition on kind of transitive assignment of those rights? You give it to someone else who then assigns it to a private developer. How would that be enforced?
Well, I mean, there's nothing that says when this tenants association buys it, they then can't sell it to somebody else. They can't sell it to a developer. Again, this is not an affordable housing bill. This is not a bill to create more rental housing, right? In fact, as I think about it, it's probably the opposite, especially for you smaller owners, right? If you have a 2-family and you're living in one side of it, you probably aren't going to rent out that side of the house if you move to Florida. You're going to keep it off the market. If I tell you that in a year when you decide to sell it, you're going to be subject to this law, you're probably just going to leave it vacant, or at least I would advise you to, right? And like Chris, like you said, small property owners provide a tremendous amount of housing that's often overlooked, right? We look at the big owners, not the small owners. If you start pulling off your single family home rentals or your 2 families because you don't want to be potentially subject to this law when you move out of the state to your retirement home, all those properties come off the market. So it's not an affordable housing law. It's not a rental housing creation law. And I think that's really important to note. All of things that we think we should do, right?
Right. Yeah, absolutely. So one second, let me just quickly see. I see we've gotten a number of questions from the audience.
I just wanted to clarify one thing as Chris looks at the list of questions, because there are property owners who have, more than 3 tenants. They might have 5 or 10 or more. Just for the purpose of clarification, is it true that each of, let's say, 10 or 20 tenants could prolong a closing process up to 2 years, thereby making it impossible for the owner to sell the property on terms that are favorable to the owner?
So it's the tenants association that has the rights.
Okay.
What we often find is, and what we see all the time with these types of bills and laws is, they lead to litigation, which leads to delays, right? I've got 10 tenants. How did they create the tenant association, right? It's our 5, not your 5. This person didn't sign. There's a petition signed, but that person didn't really sign it. And again, what happens to the minority, 49% or whatever, who voted against this? What are their rights after that? What if I vote for it, but then I don't like what's going on with the tenants association? Can I change that? This law says there's a presumption that for a year, this is the tenants association. What if I want to vote the bums out because they are not doing what I want to do? What does that lead to?
Right.
And there were lots of cases in DC where you had competing factions fighting and litigation ensued.
Right. Makes sense. So I think we need to get to the next speakers soon, but I have one last question that's related to Carlton's question about whether these are examples for Somerville in particular or a hypothetical example. I think the answer there is that this is mostly describing the state level proposal, but there is, I think, a follow-on question that can be asked there, which is there's a graphic that I've seen from the Somerville proposal that I'm posting in the chat now that says that Somerville's proposal can have delays of up to 7 years, actually, as opposed to the 257 days that you're mentioning. Now, with the Somerville proposal, because that delay is so much longer than the state level one, still not be allowed without special allowance from the state?
Well, I'm going to leave it to Attorney Broadley to talk about the Somerville stuff. But again, this is an enabling statute, right? It doesn't say you have to enact this. It says, towns, you can, and here's the parameters of what you can do, right? And here's the timelines for that. So could a town, through other means, adopt other ordinances, other regulations, other zoning things? I'm going to leave that to Attorney Broadley to talk a little bit about. But this is just an enabling statute for this, this law, right? Towns could try to do other things for sure. Whether they're legal or not is the big question.
Great. Okay. Well, thank you very much for that. That was some incredible detail on the state level proposal, and that's also a perfect segue to turn it over to the SPOC panelists. So thank you, Jeff. Great.
My pleasure. Thanks for inviting me.
Turning it over to Amir and the SPOC panelists.
Thank you, Chris. Thank you again, Attorney Turk. It's my pleasure to introduce Mr. Steve Bremis, who is the chairman of the Somerville Property Owners Coalition, and Attorney Stephen Broadley. I'm just curious. I know that this has been going on since 2019 when Somerville passed that brutal ordinance that restricted condo conversions. I'll start with you, Mr. Bremis. Can you give us a summary or an update about what happened in 2019 and where we are now?
Well, specifically, it dramatically decreased the amount of condo conversions, without question. It took away property owners' rights, potentially. As far as the conversion is concerned, it placed severe restrictions on the length of time for the conversion process. So if the unit was vacant, it takes a year to get approval. If it's occupied, it takes 2 years. It instituted money to go to the tenants, and that's been somewhat abusive too. I've heard of situations where that weren't covered in this, proposal. I heard from actually a property owner recently who was converting their units to condos and had no intention of ever having the tenants leave. It had already been renovated. They were just separating the ownership. One of the tenants actually went and found a house. The owner was never asking them to leave the premises. They've bought a new house and they demanded their $6,500. And the conversion was never filed with the condo review board. So there's a lot of injustices that are going on. But even aside from that, there's a lot of the components that were talked about earlier, which you have to offer to the tenant, you have to offer it to the city of Somerville before it can even go on the market. Aside from that, there's also rent control overtones, which, that no one's allowed to raise the rent during that time period. But so to really put numbers on this, the year prior to this ordinance, there was 234 condos approved. The year after this ordinance, there was 10. So there was like a 95% drop in condo conversions. The other side will claim that they didn't stop it. Well, they didn't. If they didn't stop it, what do what's a 95% drop in conversions? So in any case, it was, everything was very dramatic. What was in place before too was extremely strict. And this just went over the top to the point where we filed suit against the city of Somerville. We're not looking to eliminate it. We are looking to make it more palatable. And we're not trying to eliminate affordable housing. We think there's other ways that this can be dealt with other than holding the small property owners hostage. I mean, the attack is really on the small property owner. That's what we have a problem with. So it's been in process for a while. Steve Broadley, I think what we filed was 85 pages worth of response. Is that correct? So
Yeah.
it's finally coming to fruition, but I'll let Steve take it from here and tell you exactly about the suit and where we're at. He can give us an update.
Okay. So I think what I've come to as a conclusion is that contrary to what the preamble of this ordinance said, it seems to me that what the aim was to freeze the housing stock the way it was. The city council apparently just wanted to say, let's just keep it the way it is. Keep these rents the way they are. Don't go changing things because the prices will go up. They didn't talk about creating new housing, even though they said that was an emergency reason to pass the ordinance. It doesn't create new housing. It puts your feet in mud if you want to make a change. Instead of looking at a year or two to go through a process, it could be 5 years and it could even be 7 years. You try to find some buyer who wants to sit out there and wait for 7 years while you go through the process if it's an elderly or it's a low or moderate income person. And if you can't find alternate housing for that person, stack on another 2 years at the end. So there was, as Steve said, there was an earlier ordinance in place, but shorter timeframes, not as many additional items that went in. So the status right now is we filed suit and we now have an argument on our summary judgment motion next Tuesday afternoon in Middlesex Superior Court, where we're going to present the arguments to a judge in the Superior Court, and the city will come in and argue against it, and we'll see what happens. We're asking the court to either knock out the ordinance entirely or pick out those parts that are improper. And we've always been ready to sit down and discuss with the city. As Steve said, look, doesn't have to be this way. If you want to sit down and reasonably talk about the elements of this that make sense and the timeframes that make sense, we're happy to do that. Don't see any movement from the other side about that kind of a conversation. So we're out there doing battle, and it'll come to a head now pretty soon. The judge will listen, and then we'll have another waiting period while we wait and see what the judge decides to do.
And
there are some of the in this ordinance. There are some of the same issues as we've already sort of alluded to, as the Topa thing, particularly the one about the privacy issues. One of the things that's required is that if you have a vacant property, or whenever you signal your intent to convert, you have to provide to the city names and identifying information for prior tenants that you had back for a period of time. Well, those people may not wish to have their privacy disturbed. You can get yourself in trouble passing on information like that if you don't have their consent. And why should they give you their consent? Or why shouldn't they ask for money to give you consent? So there are issues like that. There is the rent control thing. It leaves you at a point where you have incredibly small allowances that you can add to your rent for the entire period while you're waiting for this. It puts in that rent control. It also, we think, on the more technical aspects of it, it wrongfully exceeds the authority that the city had under a state statute and under their own home rule statute, and it goes beyond and it contradicts the state statute on condo conversion. And in that way, we think it's overreaching and it's beyond their authority. And that's our biggest general argument against the ordinance, that they decided to take it in hand to go beyond what the state said repeatedly was a definition of what condo conversion could apply to, and who are the people who are supposed to get the benefits of condo conversion. So we got our arguments coming up, and we will see what happens. But it certainly is very reminiscent of just the kind of thing that Jeff was talking about before.
To interject for another second too, I'm going to tell you, I heard from a developer who had 25 units approved, I believe it was. The city's declared a state of rental emergency here, which is why this condo proposal was so strict. Yeah, in this situation, one of the local aldermen actually filed to downgrade the zoning, which allows for less units and no affordable housing component. Yet what was approved by the city and by right had at least 5 affordable housing units built into that 20 units. So here they're screaming they need additional housing, and you have an alderman filing to downgrade the zoning and trying to get less units for some reason. So they're inconsistent. I mean, if you're trying to encourage housing, why are you stopping a developer from putting in units that are by right for the zoning already and trying to change the zoning to put in less units? I'm hearing inconsistencies all over the place. We're just looking for, in my opinion, yeah, things to be reasonable, just not over the top. I mean, what Somerville had before was one of the, I don't even think there's another city with a condo review board. So Somerville was the only one that had that. We had strict provisions of it before, and this is just, you know, out of control. So like Steve said, I mean, we're welcoming a conversation, and all the developers that I know in Somerville have clearly stated they don't mind contributing. They just think it's ridiculous as far as what they have to go through. And the bottom line is this: people that have been building in the city for an extremely long time and contributed greatly to where Somerville is right now are gone. I hear it over and over and over. From multiple people, they do not want anything to do with condominiums in Somerville. And there are even owners. The climate is scary to them. And I know owners that have had properties over 30 years, and they're nervous, and they put their properties up for sale. They're done. So it's very scary. There's a lot of things that are affected by what we're trying to fight here.
The classic single example of people, nervous people like Steve was just talking about, is, say it's an old couple, an old guy. He's had his house 50 years, got it for $22,000. He wants to sell out and have money to retire on. But the process that he's going to have to go through is just disabling to even consider. And he doesn't have the resources. He's a prisoner. And that's what I think what this creates.
Thank you. I have a couple of questions. Earlier, Steve Bremis was saying that between 2019 and 2020, the number of conversions went from 234 down to 10. Are there any numbers available for the year 2021?
Go ahead. I haven't seen the most recent numbers. And by the way, those numbers came from the condo review board that was put out by the city of Somerville. So it's not like we're guessing at this stuff. They actually issued their report, and those stats are on the report. And you know, I just pulled that out of there. But to me, it was gleaming. It was overwhelming, the effect.
Right. Well, Steve, you were saying earlier that Somerville already had more affordable rents in the past before all this happened, before the ordinance, compared to other cities, because of the small housing providers who were willing to do that.
Yes.
So
Somerville had a 20% affordable component, which I think is higher than any of the surrounding communities, and that was part of the ordinance before. I mean, you had to, you know, comply with that. So like I'm saying, what we had before wasn't terrible, and actually it was pretty progressive. And now you just, you know, take it to another level.
Tell me, back in 19, did the city council in Somerville decide to do all of this covertly, as far as you know, making the proposal for the ordinance, or did property owners have a chance to to actually weigh in and voice their concerns to the city council?
Oh, no, really good question. No, it was pretty much done by cover of night, so to speak. There was a second meeting that was supposed to be held by the city that was never held and canceled, actually. And it was done during the summer, when a lot of people weren't paying attention. And I'll tell you, most of the people didn't know about it. Property owners weren't informed, that we're aware of, and the people that we talked to personally, and they were numerous, had no idea this was out there. And I would think that the small property owners should be notified and their voices should have been heard. You don't sneak things through, and that's exactly what happened here.
Yeah, I was going to ask you, is this among the arguments you're making about the problems with this ordinance and the way it was implemented, given that people were not really notified properly?
I think it's a collateral argument. It's really not the central argument. I think it's a more direct thing is to take on the character of what they passed. That's a comment to make and aside, but I think it's not going to carry the day without the other points. I would just say one of the results of this process and getting together the group to file this suit that's been, to me, very valuable is the formation of SPOC SPOC, because it's formed a group which does provide a conduit for property owners to get information and to gather together and do some things politically and just in terms of informing people that I don't think existed before. And I think in terms of the long term, that's probably a very helpful result of this process.
Mm-hmm.
I know people that actually actual cases. I heard from a lawyer who was trying to do a condo conversion with somebody that bought a house. It was vacant at the time. Some of them were occupied by family. They've closed on this and they are unable to get a conversion permit for a year. I mean, and they have to carry an empty house for that period of time. So it's the restrictions, severe restrictions, which led to the drop in the conversions. And I heard from a lot of people directly. I heard from lawyers that were involved, different developers that were trying to put stuff through. And no, COVID had nothing to do with it. I mean, there's plenty of people that want to do business in Somerville that are very much restricted. And there's a lot of housing that could have been created that's not going to be created at all because the developers are gone. A lot of them. And there are some new ones coming in, certainly. And you can definitely see construction going on, but it's an arduous process. It's brutal.
What can you tell us about estate planning? I know that there was a question out there. Someone was wondering if an owner had created a will, especially prior to the introduction of this ordinance, would that, and let's say the person wanted to turn over a number of units or the property to his or her children, would that arrangement be null and void even if it was put on paper before the ordinance was passed?
There was I think there was a restriction on the number of units that could be just passed without having to go through this. I don't have that at the tip of my tongue right now, I'm sorry, but there was the classic situation. Somebody buys a 2-family house and one for one kid, one for the other kid. But there was a restriction on how many units could be transferred to family members without going through this process. And it still put a cramp in the estate planning process.
Mm-hmm. Well, I know that a lot of first-time home buyers, they tend to purchase condos because condos are generally more affordable. So is it fair to say that this ordinance has hurt a lot of those first-time home buyers?
No question. Mm-hmm. Yeah, no, it definitely has.
Yeah.
I mean, if you listen, there are situations where, someone might own a 2-family and be able to put in a 3rd unit, but the city, with the affordable housing component, it has to be 20%. That 3rd unit has to basically be affordable. I've represented a development that units were selling for $189,000, and the market value of the unit was $600,000 to $800,000. So the bottom line is this, that developer is not going to take huge losses and create housing. I mean, that particular project, there was probably $3 million worth of housing, more or less gifted towards affordable housing. And that was before all of this. So, you know, at what point are you accomplishing your goal? You really have to consider the fact that it's these small developers that are creating a lot of this housing. The 20% component was being dealt with, and it was highly successful because some of them created a lot of affordable housing. But then you decided to make it even more strict than that, and now people don't want to build them at all. I mean, that's certainly hurting, in my opinion, affordable housing a lot.
Yeah, we were testifying at a hearing on Topa some time ago, and one of our members said that it's very difficult because when you try to sell a property and when you try to buy a property, time is of the essence. And there was a high-ranking official from Somerville who, when it was this person's time to speak, he turned around and he scoffed at that. He said, "What do you mean? Time is of the essence for whom?" Those were his exact words. How would you respond to that? Is that willful ignorance, or can you put a label on it? How does that make you feel when you hear an elected official from the city speak that way?
It's very disconcerting. And you know what? I mean, bottom line is this: they've come out publicly as socialists. I remember, God, over 2 years ago, there was actually a table outside the chambers at City Hall for hearings and things, and it was socialist, selling their newspapers and buttons and things like that. The bottom line is, you know, it's the free market that's creating the housing, and if you're trying to take away all the developers that are building them, then the city really needs to step up. The city's going to need to build it because you killed everything for the developers. So now who's going to create the affordable housing?
Right.
The city's going to have to do that. And they haven't stepped forward, and they really should. I mean, I've heard people mention, you know, there's definitely empty sites in Somerville. You have affordable housing areas. You can make those projects bigger. I don't see any, you know, effort put in by the city to create these things. However, you know, the small property owner who sits on a nest egg, and I'm going to say this, a lot of the small property owners that have had their properties for 25, 30 years or longer, they actually charge the most affordable rents in the city. They charge below market because they want someone that's good, that's going to live in their property, that they don't have to worry about, and that they're comfortable with. So the attack to the nest egg, and that some of these property owners, that's all they have, it's unjustified. And there needs to be a different approach to accomplish what everybody's trying to. And this is not it. Believe me, it's not working. Bottom line is, you shouldn't be stopping the developers. You should be working with the developers. I know numerous developers that would be willing to contribute as a cost of business, would be willing to pay, you know, whatever, a fee, a contribution. I mean, and that put towards some type of fund that helps the city create more housing. I mean, that to me seems like a logical, reasonable solution. The city has achieved such great heights because of the developers. And I'm going to tell you, a lot of properties that are purchased by developers, it's too much money to repair them. And other buyers many times do not buy them. The worst of properties are turned into the best of properties because of, this free market system, if you will, and someone that's going to create condos. I can't tell you how many houses I've seen, and we had an example about 1.5 years ago. There was a property that had been on the market for 45 days, reasonably priced, needed a ton of work. No one wanted to buy it. It was just too much money for someone to handle. So yes, a developer comes in, takes an eyesore, makes it into a beautiful place in the neighborhood, and that's what transformed a lot of what Somerville is right now. But the whole point is getting people to work together, not 100% one side or 100% the other. And I think if everybody's working together, they can accomplish a lot more than just, you know, laying down the hammer and no discussion. It doesn't work.
And on that note, I thank both of you gentlemen for speaking to us. We greatly appreciate it, and I'll turn it over to
Amir,
Chris.
really quickly, I'm sorry. So certainly this stuff takes money. It takes considerable money, and we're trying to fight to make all, for all property owners. And, certainly any contributions to SPOA or SPOC are very much appreciated. Without question, it's a battle, and we all have to be in this together.
I thank you for that, Steve. And we also want to say that we're definitely rooting for all the property owners in Somerville who are suffering through financial and emotional strain. So it's very important to donate. And we thank both of you again. I'll turn it over to Chris now, who will introduce the next panel.
Right, so now we're moving on to talk with Richard and Jim of Preti. So Richard and Jim, what do you see as the political prospects of this bill on the Hill right now?
Richard, do you want to start, or do you want me to start, or? Oh, you're on mute. There we go.
I'm sorry about that. I will start. And just listening to this whole thing, I wear sort of two hats. I owned a real estate brokerage for 20 years and oversaw about 3,000 sales. And I think a lot of the stuff when Jeff was explaining the bill, he brought up a lot of good points. And I can just tell you that in the normal course of business, or trying to put a deal together, this bill is unworkable in the real world. And I've sat down with sellers on a lot of occasions who have taken lower offers. It isn't always about the money. It's about the contingencies. If you're in financial trouble and you need to sell right away, an offer that's a cash offer, you'll take less money than somebody who's financing because you can close quicker. So I always, my other hat is sort of being a legislator and understanding how things work. And there's an old expression that no man's life, liberty, or property is safe when the legislature is in session. And the property part is certainly true for this bill, because you have the government here telling you, who you can sell your property to and under what conditions you can sell. And it's a huge overreach for those, for government in general. And for those people who are worried, about upholding property rights, this bill is unprecedented. No other state has done it. And it's a huge problem. And I will say that, something Jeff had said at the beginning is this sounds like motherhood and apple pie when you read the title of the bill. Who doesn't want to give people opportunity, to purchase property? And I would just say, because of that, a lot of, there are so many things that we're focused on right now. Eviction moratoriums, rent control, transfer taxes, eviction ceiling. That last session when this came up, it was almost like a step, just came out of nowhere, and it made it to the governor's desk. And fortunately, the governor vetoed it at the very end of the session, and time ran out and the legislature couldn't override the veto. And, so here we are, a lot of people would say, oh, this is so extreme, it couldn't possibly pass the legislature. It already has. And there are some legislators who are there that we're never going to convince. They're just not with us, on the issue. But the great majority of legislators, I do think, are open-minded. They want to learn, and they're not really educated on what Topa is and the dangers that this bill presents. It just sounds like a good thing, and maybe it's a solution to some of the, the high cost of housing and the housing stock problems we have right now. And it's really our job to educate legislators. SPOA is doing a great job right now, bringing this issue up, having this webinar today. We've had a lot of conversations with legislators, explaining the details of actually how this will work. Don't forget, most legislators, maybe they buy a house and sell a house once or twice or 3 times in their life. So they don't understand all the, the process and the added time that this puts on to sales. So we really have a lot of conversation. We have conversations to have, and we have a lot of work to do to make sure that, that we're educating people about this and stopping this bill from advancing any further. And Jim,
Yeah, thank you, Richard. So just to sort of agree with all that, and then to underline it, I think what happened the last session is actually a point that Mr. Turk brought up, which is that on first blush, when you look at the title and when you look at the concept, it seems like it's a good solution because it doesn't harm property owners. They're getting fair market value for their properties, and a lot of legislators and chairmen and leadership who may have should have probably taken a deeper dive to this, saw this as the solution that they could offer housing advocates that did not go so far as rent control or some of the other more severe, from our perspective, policies that were being proposed, and they felt a need to address housing issues, and this was the one that they chose. And I would agree there is a definite deficit of knowledge about what the harm that this proposal can cause. Procedurally and sort of the blocking and tackling of the legislative process, the bills that Amir mentioned at the beginning have been extended, meaning they are still under the committee. They are still in the Housing Committee and being analyzed by that committee until May 9th. At which time the committee will make a decision on what happens to them. They could either remain in committee as sort of being studied, or they could be reported out or reported unfavorably. And we are working with the House and Senate chair on those bills. However, again, we are to a certain extent working against momentum in the wrong direction because these provisions have passed previously. In the best case scenario, if they do not get reported out favorably, there will be other opportunities for proponents to propose these measures. There are a number of large omnibus pieces that will be coming up, including budgets and supplemental budgets and economic development pieces, and probably a housing piece as well, that would provide proponents of this proposal the opportunity to propose it again. So even if, is a long way of saying, if we get past the 9th of May, we still have a long way to go to make sure that this doesn't make it to the governor's desk again, with the real deadline being July 31st, which is the end of full formal sessions in the legislature. So after that, the legislature would not be able to adopt this because it would take unanimous consent of all the members, and there certainly is not that. So we have a bit of a sprint to July 31st.
and this made it through last time as an amendment, very innocuous amendment to the, I think it was the economic development bill,
Right.
That nobody expected it to make it to the, into the final version.
Got it. And so in terms of the, in the event of some version of this bill passing, do you think that some of the potential modifications that Jeff suggested in terms of decreasing the timeline, building in some level of consideration for the contingencies of the offer, or mitigating some of the harms around privacy here, are any of those things that you think would be likely to be successfully added to this?
So I think that it's certainly possible that we could get them added to it and changes made. I will say and there are policymakers who want to listen and I think would be willing to entertain some of those things. However, I'll tell you politically, making those changes will be just as difficult as killing the policy outright, because from what we have seen, the interest to compromise on the part of the other side, on the part of the advocates, is not there. So they will fight any changes. Again, I'm generalizing, but they'll fight any changes to the proposal as written, which they will term as watering down rather than improving. So what that means is, from our side, we will need folks to weigh in with their representatives and senators, be very vocal about the need for changes and/or obviously, opposing the legislation outright, because the other side will be very politically active on this issue.
I think that a lot of attorneys, I can tell you from my previous experience, a lot of attorneys will advise clients not to enter into right of first refusals anyways. I mean, regardless of this bill, if it's just two private parties, because they're so complicated and a lot of times they don't work out, and there a lot of lawsuits can pop up from it, and for the government to step in and be requiring the right of first refusal, it's just a bad thing. I don't see, if, again, from a property rights perspective, how this bill can be modified without taking away the rights of people to be able to sell their property, under the best terms and the best conditions. It's just really problematic. And I would say, this is, to me, like why it's so important to have SPOA and have SPOA out there, because on a lot of these issues, there's only really been one side that's presented, and that's the professional advocates who are at the State House all the time, just constantly moving the ball forward. We, as property owners and in the real estate community, really haven't done as good a job, particularly over the last 5 or 10 years, establishing relationships with legislators and bringing our point of view to the table when these discussions are taking place. And what SPOA has really done over the past couple of years has been really important, because I really do feel like we are part of the conversation. There's a lot of work to do, but if you're watching this and you're a member of SPOA, please get involved, because this is all about, there are 6,000 to 8,000 bills filed every year. Most legislators don't, this isn't their area of expertise. They don't understand a lot about the sale, but if they are hearing from people from their district, if you can set up a meeting with your legislator and have Jim and myself or Amir and Chris come with you, we can go over some of the issues. We have to establish those relationships with the legislators. They will listen, and again, we have a lot of work to do. So we need help, basically.
Richard, thank you. And just one question came in. How do you think the banks are going to respond if this passes? If you know, or if you have any inkling?
Well, it's going to make consummating a sale really difficult. I mean, if you're a bank, how can you give a pre-approval letter to a client, knowing that they're in a right of first refusal situation? I mean, you certainly can't lock in on a rate if this is going to be a 6 or an 8 month closing and you don't even know if you're going to close. So that's another whole issue. And then you have the whole issue, we're all living through this great real estate market right now, but sooner or later, this is going to, it just has to happen. It's going to turn into a market like we've seen before, with a lot of short sales and foreclosures. And you're going to have situations, where people are trying to prevent a foreclosure or prevent a short sale and need to sell really quick. And a provision like this is really going to hurt a lot of people financially, because they're not going to be able, to consummate a sale with this type of restriction put in place.
Thank you. Thank you very much. Either Jim or Chris, do you have anything to add?
No, thank you. This has been, go ahead, Chris.
No, yeah, that's all for me for now.
Okay, well, folks, I'll just say in closing, please remember to donate to spoa.com/join. Be sure to add the words Topa webinar in the comments field when you donate. And I just want to close with a statement that was written by one of our SPOA members when we were testifying against Topa fairly recently. He was an older gentleman, and this is what he had to say. And I quote, "My rental properties are my investment. They represent all that I have worked for over the course of my life. To pass a bill that would devaluate them overnight would be devastating and wholly unfair. Small rental housing providers like me have the responsibility to maintain their properties and provide safe, clean rental spaces for their tenants. To suggest, however, that tenant rights extend to the ultimate control and disposition of the property is simply unjustifiable in any free society." So, ladies and gentlemen, that's what we're fighting for. We're fighting for a fair, equal playing field on both sides for both tenants and property owners. Please join us in our efforts. And having said that, I wish you all a good day. Thank you very much to all the panelists. Thank you, Chris. Thank you to Mr. Lucas Krolak, who helped us with the technology. And we'll see you again. Have a great day.
Thank you.